In this video, I'm going to discuss how California Bar Exam essays are graded. The written portion of the California Bar Exam consists of 5 essays and 1 performance test. There are 700 possible raw points available for the written portion of the exam. That breaks down to 100 raw points per essay and 200 raw points for the performance test. Each essay is actually scored on a scale from 40 to 100, and the graders score in increments of 5, so 40, 45, 50, 55. You won't see a score of like a 47 or a 62. It is possible to get a 0 on an essay if you leave the answer blank or write something that is completely unrelated to the question. The California examiners have explained, in order to earn a grade of 40, the applicant must at least identify the subject of the question and attempt to apply the law to the facts of the question. So you might have a really short answer, or you might be completely wrong, but as long as you do those 2 things, identify the subject and attempt to apply law to the facts, you should get a score of at least 40 for that essay. Generally, a score of about 60 or 65 is considered passing. In 2020, California changed the overall score needed to pass the California Bar Exam from 1440 to 1390. Prior to this change, it was fairly widely accepted that a 65 was considered a passing essay score to achieve that overall score of 1440. Now that the overall passing score is a little lower, an average essay score of about 60 is probably sufficient to achieve a passing score. It is difficult to say exactly what a passing score is on an essay because of the way the California Bar Examiners compute your overall score. They take your raw score, which is based out of 700 possible points, and then they apply an undisclosed formula to it to come up with your scaled score, which is out of 1,000 points. The scaled score is worth exactly 50% of your total overall score. The California examiners do not release information about this formula. It's also possible that they can change the formula. So that's why I say that an average essay score of about 60 to 65 is probably considered passing. And remember, you do not need to pass each portion of the exam. You just need an overall score of 1390 to pass. So you can make up for a low essay score with a higher MBE score and still pass the California Bar Exam. Additionally, I want to talk about exactly how California goes about grading these essays, because it's helpful to keep in mind who the grader is and how they're grading. California hires attorneys to grade the bar exam essays. California spends some time calibrating these graders. They all get together, they learn what a 60 answer looks like, what a 65 looks like, what a 70 looks like, so that they understand how to give scores to these different essays. This way, the score that you receive on an essay should be the same, no matter which grader is reading it. California also has a built-in appeals system for its essay grading. If your overall score is between 1350 and 1389, and remember, you need a 1390 to pass, the State Bar will automatically have graders reread your essays. If you were super close to passing, the examiners want to make sure that your essays were graded correctly. They'll have a new set of graders read your essays again. Then they take the average between the score assigned by the first grader and the score assigned by the second grader for each essay. They will then recalculate your new overall score based on those averages. If your new overall score is 1390 or greater, you pass. If your new overall score is still below 1390, you unfortunately do not pass, and California does not have a process by which you can appeal or contest that score. So how exactly do you get a score of 60 or 65 on an essay? What are the graders looking for when determining your score? The first thing that you're going to get points for is spotting the correct issues. California's essays tend to be fairly open-ended, where they'll give you a fact pattern, and then at the end of the fact pattern, the call of the question will say something like, address the arguments that this person will raise. So it is up to you to utilize the facts and identify the legal issues that need to be addressed. Each essay fact pattern typically has several major issues, and it could also have some minor issues. The major issues are the ones that are clearly screaming to be addressed by the facts. And in order to get that score of 60 to 65, You typically need to address all of the major issues. With regard to the minor issues, it's probably possible to get a passing score without necessarily spotting or addressing every single minor issue. So how can you tell if it's a major issue or a minor issue? Major issues stem from facts that pretty clearly trigger a particular legal issue. For instance, in an evidence question, if a party is offering an out-of-court statement for the truth of the matter asserted, hearsay is likely a major issue. Sometimes the call of the question will even identify major issues for you. In that hypothetical evidence essay, the facts might state, the opposing party objects that the proffered evidence is hearsay. So because they came right out and told you that hearsay is at issue, you must address that hearsay issue to get a passing score. Minor issues can be more difficult to spot. Sometimes there are facts that hint or suggest that an issue could be discussed, just for you to ultimately conclude that the issue does not apply. For example, in that same hypothetical evidence essay, maybe the person who made the out-of-court statement is dead. So you could write about dying declarations as an exception to hearsay. But if the person did not make the statement about the cause or circumstances of his or her death, then it isn't really a dying declaration. So I would consider dying declarations to be a minor issue. You would probably get some credit for accurately discussing it, but you could still achieve a passing score even if you didn't discuss it. When you're completing practice questions, be sure to review the sample student answers that have been released by the State Bar of California. California releases 2 sample student answers for each essay. If you see that both student answers addressed a particular issue, that is a hint that it's more likely a major issue that needs to be addressed to achieve a passing score. If there are issues that only one of the students discusses, those are more likely minor issues. You may receive some credit for discussing the minor issues, but you can also probably achieve a passing score without discussing them. The next thing that the graders look at when awarding points is that you correctly stated the law. High-scoring student answers also include relevant background information about the law without providing too much unnecessary information that is not needed to answer the question. For example, in a criminal procedure essay testing a Fourth Amendment search and seizure issue, perhaps the specific issue is the application of the automobile exception to the warrant requirement. Instead of just stating the automobile exception, the high-scoring student answers will start by explaining what the Fourth Amendment says, whether or not it applies to this particular situation, and how the Fourth Amendment may be satisfied, such as by obtaining a warrant or meeting the requirements of a warrant exception, like the automobile exception. However, a student who lists and explains every single exception to the warrant requirement is providing too much unnecessary information. Again, reviewing those released student answers as you're studying will help give you an idea of how much detail to include in your rule statements without providing too much information. The third thing that graders look at is your analysis of the facts. This is probably where you get the most points. It's important that you spot the correct issues, but mostly so that you can analyze those issues thoroughly and correctly. The fact patterns for the California Bar Exam essays tend to be fairly short. So there is a really good chance that every single fact is in there for a reason and should be used somewhere in your analysis. Additionally, you may even need to identify missing facts that you would like to or need to know in order to fully address a particular issue. Now, you should not make up entirely new facts or change the fact pattern, but you should identify relevant facts that would help you address the relevant legal issues. You should also address arguments for each side in your analysis. You could write, the plaintiff will argue, and then on the other hand, the defendant will counter-argue. You might argue that each side might interpret the facts differently, or maybe one party will argue that the majority law applies, while the other will assert that the minority law should apply instead. After identifying each side's argument, tell the grader who has the stronger argument. The fourth way that you can earn points at a California Bar Exam essay is by reaching the correct conclusion, when applicable. Not all essays have a right answer. If you look at the released student answers, sometimes you will see that each student reaches a different conclusion. This is an indicator that there is no right answer to this question or this issue, but the graders will probably still give points for a conclusion that logically flows from your arguments. Sometimes there is a right answer, and when this is the case, you will get some points for reaching that correct conclusion, because coming to the correct conclusion shows the grader that you really understand how the law should be applied to the facts for that issue. Let's take a look at a sample California bar exam essay and discuss how to get the most points possible. This is a torts essay from the February 2019 California bar exam. It says, Dan, a dog breeder, had some 8-week-old puppies to sell. Bob and Carol went to his house to look at them. Dan invited them into the living room where the puppies were located and said, "Whatever you do, don't go into the room at the end of the hall." As they were examining the puppies, the largest puppy, without warning, gave Carol a nasty bite on her hand. Dan told Bob to go to the bathroom near the end of the hall to retrieve some bandages. Forgetting Dan's earlier admonition, Bob opened the door at the end of the hall, thinking it was the bathroom, and entered a darkened room where Dan kept an enormous pet chimpanzee. The chimpanzee jumped between Bob and the door, beat its chest, and made menacing hoots. Frightened, Bob stood still. In attending to Carol's bite, Dan mistakenly grabbed a bottle of heavy-duty solvent, thinking it was a bottle of antiseptic. When Dan rubbed its contents into Carol's wound, she began to scream and shout in pain. Hearing Carol's cries, Bob barged past the chimpanzee, which gave him a deep gash to his head as he passed. Shaken and sore from their injuries, Bob and Carol fled Dan's house. Bob and Carol filed a lawsuit against Dan to recover for their injuries. Number 1, what claims may Carol reasonably raise against Dan? What arguments may Dan reasonably make? And what is the likely outcome? Discuss. And number 2, what claims may Bob reasonably raise against Dan? What arguments may Dan reasonably make? And what is the likely outcome? Discuss. As you can see, the examiners do not tell you what the legal issues are in this question. They tell you to identify the claims that Carol and Bob will raise against Dan. The examiners also specifically instruct you to address Dan's responses. So, we need to consider Bob and Carol's potential legal claims and Dan's defenses to those claims. Starting with Carol's claims, she was bit by a dog. A dog bite could give rise to a negligence or a strict liability claim. This essay question does not state to apply California law, so you should apply general law. Some states treat dog bites as strict liability offenses, while others do not. So you should address both the possible negligence claim and the possible strict liability claim. Even if it's unlikely that she would succeed under a theory of strict liability, since most states do not apply strict liability to dog bites, it's still a good idea to raise that as a potential argument or claim. In your analysis, you should discuss why she would not likely succeed on a strict liability claim. The question says, what claims may she reasonably raise, not what claims can Carol successfully assert. So even though it might be a very weak claim, you should still address it. She also sustained an injury with the heavy-duty solvent. That's another possible claim for negligence. The analysis of this claim is dependent on different facts than the analysis of the dog bite negligence claim, so you should address them as two separate issues. There is also a potential premises liability issue. Because Carol and Bob are on Dan's property, he owes them a duty as a landowner. Dan's defenses to these claims could include contributory negligence, comparative negligence, and assumption of the risk, which are the defenses that are applicable to strict liability and negligence claims. Some of these issues are major issues, meaning that you probably have to discuss them to get a passing score, and some are minor issues. The premises liability issue is not as obvious as the negligence or strict liability issues, so you could probably still get a passing score even if you didn't mention premises liability. And contributory negligence is an antiquated doctrine that most states have abolished at this point. So if you didn't mention it as one of Dan's responses, again, you could probably still get a passing score. Now, if you have time and you did mention those issues, they would probably generate some additional credit and can help you get an even higher score on this essay. With regard to Bob's claims, he can assert a claim for negligence as well as a claim for strict liability for that chimpanzee injury. Like Carol, he can also raise a premises liability claim. And then Dan's defenses would be the same: contributory negligence, comparative negligence, and assumption of the risk. It is important to address these arguments again because the facts are going to be different. When you address a legal issue more than once in an essay answer, you can simply state the rule the first time you address that issue and then say, "See rule above," when you address that same legal issue in future instances. Here, for instance, if you state the entire rule for negligence under the issue where you discuss Carol's claim for negligence arising out of the dog bite, you do not need to restate the entire rule for negligence when you address Carol's claim for negligence arising out of the solvent injury or Bob's claim for negligence arising out of the chimpanzee injury. You can just say, "See above." Your handout includes one of the sample student answers that the California bar examiners released for this essay. I don't want to read the entire answer to you, but I do want to point out a few things about it that I think are helpful in understanding what it takes to get a high score on a California bar exam essay question. First, this is a pretty long answer. While you probably don't need to write quite this much to get a passing score, it is important to write long answers. You have an hour to answer each essay question, and the graders expect you to be writing pretty much that entire time. Now, I know that the released student answers can be a little intimidating because sometimes it's just not possible to write as much as these students. Some people are just not that fast of typists. Well, keep in mind that California has selected these student answers because they consider them to be some of the best student answers to these questions. Even if you don't write quite this much, you can still pass, but you should try to write a long answer to each essay question. One of the reasons this answer is so long is because this student includes a lot of detail in their analysis. And as we discussed earlier, this student uses all of the facts that are in the fact pattern and identifies missing facts that would be helpful to know. For instance, with regard to the strict liability claim for the dog bite, the student writes, "A puppy would likely not be considered a wild animal for strict liability purposes. However, the owner of an animal with known dangerous propensities is also strictly liable for any damage caused by that animal's dangerous propensities. An owner will not be charged with knowing the dangerous propensity unless some circumstances exist which give him reason to know of the animal's dangerous propensity, such as a prior incident of biting." The student continues, "Here, Carol will argue that Dan should have known that the largest puppy had dangerous propensities. However, this is unlikely to be successful because the facts indicate that the puppy bit Carol without warning." Here the facts are pretty limited with regard to whether Dan knew or should have known that the puppy might bite someone. It just says that there was no warning. But maybe this has happened before. Also, notice how the student phrases the analysis in terms of each party's argument. The student begins, "Carol will argue." The student also recognizes that Carol's argument probably won't succeed since the bite occurred without warning. The student goes on to say, "Further, it is generally known that puppies have a tendency to nip and chew, but they don't bite hard enough to give nasty bites often enough that a reasonable person would know of a dangerous propensity to give nasty bites." The student includes generally known additional facts that would be helpful to the analysis of this issue and are also probably facts that a judge deciding this case would comment or rely on. The student concludes, "Thus, Carol will not succeed in showing that Dan should be strictly liable on the basis of a known dangerous propensity." Even though Carol probably won't succeed on a theory of strict liability, there are sufficient facts in the fact pattern to suggest that you should nonetheless discuss this issue. This student correctly points out that strict liability usually only applies to wild animals, not domestic animals. So by addressing this issue, this student shows the grader that he really understands this particular distinction and that strict liability likely does not apply here. You would still get credit for discussing this issue even though Carol won't likely succeed. The student continues in a similar manner for all of the other issues that we identified. You should also notice how organized the student's answer is. They use different typefaces to separate the multiple pieces of the answer. They number the headings to indicate which call of the question that they are responding to. They use bolded, underlined headings to identify the various legal claims and defenses. And then they use bolded headings to identify the sub-issues, such as the elements of negligence. As you're practicing, pay attention to the similarities you see amongst the high-scoring student answers. You can learn a lot of valuable tips that you can implement in your own writing to help ensure that you get a high score on your essays as well.